Hi again, my friends. This is attorney Russell Araya of Ramos Law Firm. Thank you for joining us for another episode of our House of Law series. Today we're going to be talking about verbal and written statements to law enforcement. Stick around. So today we're going to be talking about statements to law enforcement. That's police officers, detectives, any other investigators who are working for the government to investigate a crime that you might be the subject of. Now, it's very important to know that there are two types of statements. A verbal statement, something that you say to the police officers, or a written statement, something that you write down and hand over to the police after you've signed it. Now, the thing is that these statements can be used against you in a court of law. Whether you're guilty or not is irrelevant for this conversation. The reason why I say it's irrelevant is because, let's say, for example, you didn't do anything, and the police say, hey, we'd like to talk to you. Well, you may come across as a nervous person, and you might say certain things that might be construed as implicating you in the crime. You might think you're helping yourself, but in fact, your words could be twisted against you. And that's not your fault. It's just simply the nature of the investigation process. You're a human being, and you can be caught up or caught off guard. It doesn't mean the police are doing anything wrong. It just means that you need some guidance, and the guidance would be the help of an attorney. So if you do plan on speaking to the police about a crime that they are investigating, my advice to you is ask for an attorney to be present with you during that questioning. That attorney can then guide you through the process. Now, if you do make a statement, of course, those statements can be used against you in a court of law. Now, you could be admitting to certain crimes, you could be admitting to being somewhere when the crime occurred, and the district attorney will use that evidence against you. Your attorney naturally can try to influence the jury or the judge that what it was that you wrote or what it was that you said to the police was misconstrued, to try to help push the arrows away from you. Now, another option, of course, is to not say anything. That's called exercising your Fifth Amendment privilege against self-incrimination. So don't say anything and respectfully decline to answer any questions. Thank you again so much for joining me for another edition of our House of Law series. We'll see you next time.